Does your company need a labor agreement? Let's say you run a growing company in regional Victoria. You've got contracts lined up, equipment ready, and deadlines approaching fast, but you can't find enough qualified project managers or heavy machinery operators. After months of searching, you finally find the perfect candidates overseas. Skilled, experienced, ready to start right away. There's a catch. Your occupation isn't on the skilled occupation list. One is over the age limit, another doesn't meet the standard English requirement. All that time, money, effort you put into the right people feels wasted. Meanwhile, your projects stall, deadlines are missed, and your business growth is on hold. Situations like these aren't rare. This happens to many companies across Australia, from farms to construction to hospitality, and that's exactly where alternative options like labor agreements come in. In this video, I'll break down how labor agreements might be the right solution to help you sponsor the skilled workers you need. Hi everyone, this is Walt Collis, your trusted migration lawyer. What are labor agreements? So you finally find the right people, skilled, experienced, ready to jump in. You're thinking, the hard part's done. And then you check the skilled occupation list and the job title you need isn't there, not even close. Suddenly that dream hire becomes a dead end. And just like that, you're back to square one, reposting job ads, chasing recruiters, redoing interviews, and losing weeks that you simply don't have. This is exactly where a labor agreement comes in to help. Instead of throwing away months of recruitment work and starting over, you partner with a migration lawyer to apply for a labor agreement. You build a case showing that local hiring hasn't worked, that your business is growing, that these candidates are essential to fulfilling current projects. The government reviews your case, sees that you're contributing to a regional economy, and approves the agreement. Now, not only can you sponsor those two workers, but you also have a framework to bring in more employees as your business scales. How to know if you actually need a labor agreement? If you encounter one of the following situations, you might need a labor agreement. Number one, you can't find enough suitable Australian workers. Number two, when your recruitment efforts have failed to attract qualified local applicants, especially in specialized or lower population areas, a labor agreement can allow you to access a broader overseas talent pool. You need to sponsor workers and occupations not on the skilled occupation list. Many fast-growing or emerging industries face this exact challenge. Labor agreements can make it possible to sponsor workers in niche or unlisted roles if a strong business case is made. Or maybe when you found a great candidate who doesn't meet one or more visa requirements such as age, English language level, work experience, a labor agreement may allow you to request targeted concessions. You're in a regional area or specialized industry. If you're operating in one of Australia's designated area migration agreement regions or within an industry that already has a template agreement in place, such as aged care, meat processing, or horticulture, you may already qualify for streamlined access to skilled migration support. Why standard hiring routes are failing. Australia is facing a massive skills shortage in many skilled areas, but the current occupation list can't keep up. Furthermore, the stringent requirements of the standard employer sponsor program may not be possible for all industries to meet. New industries are popping up, technology is evolving, and business needs are shifting faster than the government updates its occupation list. So while you're trying to innovate and grow, the system is limiting you from reaching your goal. Labor agreements give you breathing room. You can sponsor the people that you need. But here's where most employers get stuck. They know that a labor agreement exists, but they don't understand how to actually get one approved. How the labor agreement process works. Getting a labor agreement is a very serious and complicated application process that requires a strong business case. It all starts with proving a very specific point, that you've made every reasonable effort to hire Australian workers first. This means real documentation, not just claims. You'll need to show your advertising history, outline who applied, and explain why those candidates weren't suitable. This is where most applications fail, because the government wants to see a genuine need and not just a preference. Beyond that, you have to clearly define what roles you want to sponsor. That includes accurate job titles, required skill levels, responsibilities, and where each role fits into your business operations. If the roles aren't clearly aligned with your business's actual needs, the agreement can be denied or delayed. In many cases, especially for industry or company-specific agreements, you'll also be required to consult with industry stakeholders, peak bodies, or even unions. Now, this step isn't always mandatory as it depends on the agreement types. which we'll discuss later in this video. Once all that is submitted and approved, your labor agreement becomes your long-term framework. It's not just a one-off visa approval. A labor agreement gives your business the green light to sponsor overseas workers under the 482, 494, or 186 visa streams for 5 years without restarting the whole process every time you need to hire. It also lays out exactly how many workers you can sponsor, which roles are eligible, and what concessions apply so you're not guessing, hoping, or getting stuck in limbo. Now here's what it looks like in real life. A hospitality group running high-end restaurants across Tasmania was desperate for experienced staff. They'd burned months cycling through job ads, chasing recruitment agencies, leaning on referrals, and every interview led to a dead end. Meanwhile, their chefs were overworked, front of house was short-staffed, and the customers were starting to notice. Now, the HR manager reached out to a migration lawyer for help to apply for the restaurant industry labor agreement, which already had concessions built in. Within months, they had skilled overseas chefs and trained hospitality staff working legally, consistently, and with long-term stability. Their business started running at full capacity, and they started making profits sooner than expected. Choosing the right type of labor agreement. Not all labor agreements are the same. There are 3 main types, and choosing the right one will make all the difference. Let's start with the company-specific labor agreement. It's custom-built for businesses with unique workforce needs that aren't covered by standard frameworks. Now, this type of agreement will be considered only where a genuine skill or labor shortage exists for an occupation which is not already provided for under an alternate pathway. Next is the industry labor agreement. And this is a template agreement which has already been negotiated between the government and key industry stakeholders. Now, please note, no further concessions can be considered under this arrangement, which has fixed terms and conditions with inbuilt concessions. Terms and conditions may only be altered with approval from the minister. These include aged care, meat processing, dairy, horticulture, fishing, and fine dining, among others. If you fall into one of these categories, you might have a ready-made agreement that already includes concessions. For example, the aged care labor agreement allows businesses to sponsor personal care assistants and other support roles with lower English requirements and no work experience for 4H2 visas. The premium dining agreement helps restaurants bring in highly skilled waiters who meet international standards, even if they fall outside the mainstream visa requirements. If your needs align with an existing template, this is hands down the most efficient path forward. And then we have the DAMA, the Designated Area Migration Agreement. This is designed specifically for businesses operating in regional Australia. If you're based in a location like Western Australia, Northern Territory, or South Australia, the DAMA gives you access to a much broader list of occupations, many of which don't appear anywhere else on the standard skilled list. For example, a dairy farm in regional Victoria needs skilled workers not available locally and uses the Goulburn Valley DAMA. You also benefit from relaxed visa conditions, including lower English requirements, wider age brackets, and in most cases, pathways to permanent residency. This is a powerful tool for regional employers who've been struggling for years to find qualified staff. Choosing the right labor agreement is all about aligning your immigration strategy with your business goals. But navigating this process on your own can be quite overwhelming, and that's where we come in. How Australian migration lawyers can help. At Australian Migration Lawyers, we've helped dozens of businesses to sponsor skilled workers. We constantly update with new requirements from the government. We're here to help you build a strong business case, handle your application and communications, and navigate every step of the process. More importantly, we know how to save your business time, money, and stress. Whether you're hiring 3 people or 30, we help you get it right the first time. So if your business is stuck in the same cycle, don't wait for the situation to get worse. Book a consultation with our team today and find out if the labor agreement is right for you. We'll assess your eligibility, help you build your case, and guide you every step of the way. Click the link in the description. Let's get started.